just for dramatic effect.
The Court of Appeal in the 4th, 5th District of the State of Florida is now in session. The Honorable James T. Edwards, Judge presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
Good morning, everybody. I've been introduced. I'm Jim Edwards. To my right is Judge Scott Makar, a relatively new member to this court, but a veteran of the Courts of Appeal. And to my left is Judge John Harris. We have 3 civil cases this morning. Everybody gets 20 minutes per side. We typically reserve 5 minutes for the appellant for rebuttal. If you want anything different, just let us know. I'd be happy to give you whatever time you want. If you have any noisemakers, which everybody does, please turn them to silent or turn them off so that you don't interrupt your colleagues, or worse yet, interrupt one of us judges while we're asking you a really deep probing question. The setup here with the clock is fairly simple. When you have the green light, you have all your time available. When you hit the yellow light, you are into your rebuttal time. Red light, it's time to sit down, unless we say otherwise. So with that, we'll start off with Starbucks versus Gold, and that's case 23-157.
May it please the court. Megan Logan on behalf of appellant Starbucks. As I got into my car this morning to arrive at the courthouse, I was greeted by a disclaimer on the console of my car. And that disclaimer said, "The driver is responsible for safe operation of this vehicle." The driver is responsible for the safe operation of this vehicle. A concept so simple, even a car recognizes it. Yet it was overlooked repeatedly in this trial. It was overlooked first by the trial court at the directed verdict stage, then by the jury, and ultimately by the trial court again in a motion for new trial. And that's where I'd like to begin, with the denial of Starbucks' motion for new trial. The motion for new trial was based on the premise that the jury's verdict finding no negligence on the part of defendant Ward was against the manifest weight of the evidence. The evidence supported negligence as to defendant Ward overwhelmingly. And when I say that, the evidence supported all 4 elements of negligence. It was undisputed that there was a duty on behalf of defendant Ward to use reasonable care in the operation of her vehicle. That was echoed by Dr. Bushagi in his testimony, and actually even began before that, and obviously recognizing there's a difference between argument and evidence. It was acknowledged in the opening statement of defense counsel for Ward.
Counsel, what warning signs were there to let the driver know that this was a pedestrian area?
There were no specific warning signs, Your Honor, but one of the arguments made in this case is what good would a warning sign have done for someone that wasn't looking? Ward's testimony was that she never saw a pedestrian in this area in the over 300 times.
I mean, if there was a sign there, it's very probable she would have seen it at some point. I think the testimony was she just looked down momentarily, and that's all it took. And that's typically all it takes in every accident, right?
That is, Judge. And again, though, I think the suggestion that a warning sign would have prevented this accident is a little bit of a misnomer. And when I say that, Ms. Ward had been through this drive-through over 300 times without incident. And so it was this one occasion, the perfect storm, where she looked down, looked away, negligence, a breach of the duty.
That seems to suggest that this was a one-off. She'd been through it 300 times before.
I think it was a one-off, but I think it was a one-off of the perfect storm of conditions that couldn't be created, essentially if you tried. And I think the suggestion that all these warning signs, crosswalks, pedestrian crossings, all of that would have prevented this. I think, again, she and others clearly went through this drive-through on numerous occasions without any incidents, without any interactions, as evidenced by the lack of prior accidents.
What percentage of fault are you arguing is attributable to her?
You know, I think that could range, but I think the reality is, in closing argument, counsel for Ms. Gold suggested that if you're inclined to award Ms. Ward some fault or assign her some fault, it could be anywhere between 0 and 1%, and the jury went with 0. I think that's the problem, in essence. I think even 1% would have showed that the jury accounted for the evidence, which was overwhelmingly that Ward bear some responsibility for this accident. So again, I think it ranges, but I think the reality is even 1% would have acknowledged that, and I wouldn't be here making this argument, but the 0 suggests that the jury's verdict was absolutely against the manifest weight of the evidence and should have been remedied.
We agree with you, it'd be a new trial on liability only, correct?
I think so, unfortunately. I think, you know, as with anything, I think we're talking about liability, and I think we're talking about what percentage would be awarded to Ward. You know, I know there has been, you know, suggestion, even as to the other argument, that, you know, Fabre cases are applicable, and I think, again, that's not a given, but the Bada case that we cite did the same thing and awarded a new trial as to liability only. So moving back to the denial of the motion for new trial, the evidence absolutely supports all 4 elements of negligence. It supports that there was a duty and that duty was breached. And when I say that, the argument or the testimony of Dr. Bushagi was that Ms. Ward, as any driver, had a responsibility to look where she was going. When she didn't do that, there was abundant testimony regarding causation, and that Gold's injuries were caused by the crash itself. And that was found in the testimony of Dr. Bushagi, Dr. Lichtblau, and even Dr. Hastings, who opined that her injuries were the result of impact between a Jeep Grand Cherokee and Miss Gold.
Excuse me, I should know this, and I apologize for asking. Sure. How fast was the vehicle going at the time of impact?
There's an estimate about 3 to 4 miles per hour, Your Honor.
So basically idling?
Correct.
Okay.
And so...
Did Ms. Gold come out right in front? I saw there was 2 videos in the record. Did she come out right in front of where the car stops at the window, or did she come out at a different location?
Yeah, there's actually no video, Judge. There's some photographs that show the car.
Oh, there was a video just of a drive-through. It wasn't of her
Correct.
getting hurt. It was just, it graphically showed you, including the one where you had to wait in line, I guess in line with the very compelling closing argument of how thirsty and hungry you get waiting in that long line. But
absolutely. And you're referencing the videos taken by Dr. Bushagi as part of his expert testimony. But the testimony in the case was that Miss Gold, in essence, had come out of the door and around the patio, and it was as she came around the patio that she encountered the Jeep Grand Cherokee that was pulling out of the drive-thru. The only evidence that Ms. Ward was not at fault was the conclusory testimony of Dr. Bushagi that her actions were reasonable, that these were the actions of a reasonable person. I would submit that that flies in the face of everything we know about driver responsibility and or even the suggestion that she looked away for a moment and that was somehow reasonable. That's the stuff that punitive damages are made of. I mean, courts every day find people responsible for punitives for looking away, for texting and driving, for looking at their phone. And all of a sudden, based on a conclusory opinion of a paid expert, it is now a reasonable action to stop in the drive-thru and look down while your vehicle is rolling.
I'm not sure I've ever seen a case where just looking away for a moment ends up being an intentional act justifying punitive damages. I'm not sure what you're talking about.
I don't think it's an intentional act, Judge. I think the suggestion or the analogy was that, again, it's not reasonable to look down while driving, which is absolutely what she was doing. She was not stopped. Her foot was not on the brake. She was in movement. She was driving. And I think the suggestion that that's reasonable, again, is a conclusory opinion that fit the circumstances of plaintiff's case, but it should...
It certainly fits, though, in the expert's opinion that it's foreseeable and that Starbucks should have guarded against it. Correct? I mean, you agree with that.
I don't agree with that. And I think part of that is, one, how do you ever guard against drivers in your drive-through rolling? I don't know that you do. I don't know that you
But
can.
there's not a duty to make it foolproof or absolutely safe, but to take some steps to reduce the risk. I think that's what the expert was talking about, wasn't he?
Yes, but again, I think, how does one do that? And I think the idea being, would a sign have kept her foot on the brake? Would a sign saying, don't look at your coffee, pay attention to the road? I don't think any of those things.
People run stop signs all the time, but if you don't have a
Absolutely.
stop sign there, oops. I mean, so here you are, and you have people, as the one video shows, waiting in line. It's not like you whip up there unless you just have the luck of the day. You're usually in line waiting, so if there are signs or warning signs, it might, not necessarily, it might plant that in your mind, and that would be a reasonable thing for a business owner to do. I mean, that's the crux of their case, wasn't it?
Yes, it's certainly not unreasonable to do. But again, the idea being, from our perspective, when you talk about foreseeability, this had never happened before in 4 years. This had never happened before with over 140,000 cars through that drive-through in the year that this accident occurred. And so when you talk about foreseeability, what is that based on? I mean, the fact that, like you said, it could potentially happen because it's not foolproof, and that therein lies the problem. And so when you talk about foreseeability, as Dr. Bushagi did, and the fact that, you know, it was Miss Ward's actions were reasonable in rolling through the drive-through and in looking away to secure her coffee, I think that's a conclusory opinion not based on any facts or inferences in the record. And the Federated case, one of the cases we cite in support of our claim that the trial court erred in granting the fourth motion in limine, says that where a conclusion or opinion of an expert witness based on facts or inferences not supported by the evidence that in such case that opinion has no evidentiary value.
I thought there was, I'm sorry for interrupting, but I thought there was some evidence that basically said that in the design of this, there were recommendations made about having certain safety features put in, and those weren't adopted.
There were various revisions and layouts of this, some of which had them, some of which did not. And again, that segues into my empty chair defense, but those were all the decision of the landlord owner, not Starbucks. And so certainly Starbucks had oversight, had the ability to request or, again, review those, but the various revisions were the work of the landlord and hence ties into our empty chair defense in this case. So again, the same arguments made in support of the argument for denial of the motion for new trial are equally applicable to the motion for directed verdict that was made both as at the close of plaintiff's case and at the close of all the evidence as towards negligence, and we think that should have been granted as well. I'd like to touch on the duty allegedly owed by Starbucks and in turn how that flows into the empty chair defense. In this appeal, Starbucks is asking this court for a determination that under the facts of this case, it, as a tenant of a multi-tenant commercial building, owes no duty to invitees where the duty is expressly reserved to the landlord. And in the briefings, you've seen arguments that that standard is simply not applicable. It's only applicable in cases involving criminal attacks by a third party. I would suggest that's not the case. I think both the Diaz case and the Martinez-Mare case support the fact that they can be used in other cases aside from criminal assaults by third parties. The Davis case is silent as to the exact facts of that case, but there's no suggestion that it was a criminal assailant. I also think that when you look at the reasoning or the rationale behind the application of such a standard to criminal assailants, it's much more like the facts of this case than it is to the static conditions that existed in either the Levy case or the Burton cases that are cited within the briefs. You know, first of all, you talk about a criminal act of a third party, and the court's rationale in applying that standard seems to be, again, that there was no foreseeability, that there was no warning that could be given by the tenant that would have prevented such a situation. And I think here there's a similar concept in that it was a third party, Ward, that caused the accident. And again, what warning could Starbucks have given? Obviously, a warning to look for pedestrians, look for traffic, but again, no guarantee that any warning would have prevented this accident.
But isn't Starbucks a little different here than, say, a shoe store in a mall or something? Starbucks had the right basically to override any of the plans that the landlord came up with, didn't it?
It did have that right, but again, I mean, I think it's important to look at this in context, which is, you know, the services and the professionals that Starbucks utilizes and has on the project. And so when Starbucks opens a location in various jurisdictions, it does so relying on the landlord, on local building officials, on all of the people involved to ensure that it meets code, to ensure that it's, you know, that all of the safety standards and the best design possible is adopted. Starbucks looks at those plans, again, mostly from a, you know, kind of PR or utility standpoint for their operations. I mean, how many cars can you stack in a drive-through safely? You know, how many customers can you serve? Those type of things. But they are not boots on the ground, hired, you know, architects, surveyors, engineers, all those things to ensure that it's the best design, or even, you know, an alternative design.
What if there's a car backing out of a parking space in the parking area and backs over a customer walking through? Is there a duty on Starbucks there, or is it duty on the owner of the parking lot, the third party, or how does that play out?
Yeah, I think assuming it's a common area, as this was defined under the lease, the landlord takes responsibility for that. And
So I was hoping to hear more about the landlord not, you know, being part of the verdict, but.
sure, and I'm happy to address that. I see that I'm into my rebuttal time, or I can address it on rebuttal.
That's fine.
Okay.
It's your time.
Thank you.
Good morning, Your Honors. May it please the Court. I'm Curry Pagic, and I represent Sherry Gold, the appellee here, and the plaintiff below. Starbucks Corporation received a fair trial, and it's not entitled to a do-over on liability. The trial court did not abuse its discretion in any of the issues in this case, not even close. So let me address first what the defendants, Starbucks appellants, addressed in their argument to begin with, the negligence award. They have waived any appeal on that issue. They did not make a motion for a directed verdict on the issue. They waived it. 1.480A is a rule we all share. It's a rule that protects us all. It's the law in the state of Florida. Number two, they did not file a post-trial motion to set aside the verdict on the issue of negligence. 1.480B. They've waived the issue, and that's the issue they started out with here today. Even if it had not been waived, the overwhelming evidence that Starbucks negligence caused this incident. Starbucks had control from day one. They had the right to control the setup of this entire property, and they exercised that right. From up on high of Mount Seattle, they directed exactly what happened in Nassau County. Not only did they design it, they designed out the safety. There is not one iota of safety in this design. They designed it in. They took away the stop bars that were in the original design, Starbucks' original design. They took away the stop bar for the exiting drive-through traffic. Number two, they took away the sidewalk, which was there for safety, for people just like Miss Gold. Could have been a 6-year-old, could have been a 72-year-old person like Miss Gold, could have been a mom with baby carriage that got ran over.
Counsel, I'm sorry to interrupt, but I mean, let's accept that there was negligence by Starbucks. But
Yes, sir.
But that doesn't get us a resolution of the issues on appeal, correct?
Yes, sir, you're correct. The issue's on appeal. Then I will jump to those. Yes, sir, Your Honor. First, they talk about the fourth motion in limine and the issue of the duty of care to customers. Clearly, that is an issue of law for the court. The court determines the issue of duty, Not only did they not appeal, did they not move for summary judgment on that, they never moved for a directed verdict on the issue of duty. They have never filed a post-trial motion on the issue of duty.
Let's focus again on how is it okay for Ms. Ward to not look where she's going while her vehicle is moving forward. I mean, she was going slowly, but if you ask Ms. Gold, it hurt and caused her damages to the tune of like $8 million, right? So whatever she did factually caused the injuries to Ms. Gold. And how is it that a jury can find she was not at fault 1% or 0.5% or something? I mean, I think in the grand scheme of things, since it would be a trial, new trial on liability only, I don't think it's going to change the price of the Starbucks cup of coffee, but how can a jury come back with the evidence presented and not find her at least some percent at fault?
The question is, was this a zone of risk created by Starbucks? Was it reasonably foreseeable that this would happen? As the court talked
No, that's not the question. My question is, how can a jury not find her driving forward with her foot off the brake, not looking where she's going, some percent at fault?
Well, there's two issues. First, this is a question of fact for the jury. The evidence was overwhelming that this is something that is reasonably foreseeable to occur. Number one, was it negligent? Number two, did it cause the injuries? Did it cause the injuries? The jury could say, A, either one, she was not negligent, or B, the cause, the proximate legal cause of this incident was Starbucks creating the trap. That both of these...
Counsel, I'm sorry, I think, at least I'm hearing Judge Edwards wants you to address the 0% assignment of fault.
If I could refer to the case of Valenti versus, excuse my pronunciation, Sareva. It's 292 Southern 3rd 50. So it's the second DCA 2020. In that case, a motorist changed lanes into a motorcyclist.
And the motorist said he looked carefully before he moved. The jury could believe him or not. I'm familiar with that case.
Yes, sir.
We don't have that here. We have Ms. Ward was not looking where she was going with her foot off the brake, even though she's going 3 or 4 miles an hour. I mean, it's not horribly reckless like, as I'm sure you saw some folks on I-95 and I-4, it's not that situation. I mean, nobody's claiming Ms. Ward is a terrible person, but that case is not our case, is it?
Respectfully, Your Honor, this was a blind corner created by Starbucks. She came around a blind corner created by Starbucks. There was a sidewalk there for the pedestrian to step on to look to see if the exiting from, this happened in the drive-through lane, which was under the exclusive control of Starbucks. There had been a sidewalk. Starbucks at the last minute wanted more space on their patio.
I get that. Trust me, I understand that. I saw the evidence on the other Starbucks.
Yes, sir.
I find it hard to believe that the Starbucks here basically agreed with jettisoning most of the safety things other than the little black rail there. But again, somebody heading towards a blind corner who's been through there hundreds of times or at least 100 times, you know, how is that okay? I mean, it's not like a light blinded her at the last second or something like that. I mean, she wasn't looking where she was going and she hit your client.
It's the jury's job to make that determination, Your Honor. It's a question of fact.
There was no question of fact, but that she was not looking where she was going, right? I mean, it's undisputed. Undisputed, she didn't have her foot on the brake, so it was undisputed. She was moving forward and simply not looking where she was going. It's undisputed that cause in fact was she hit Ms. Gold, right?
Yes, sir.
Okay, so again, how can that not be some percentage negligent?
That's the jury's job to determine who caused this approximately.
And if the jury gets it wrong because it's against the manifest weight of the evidence, it's the judge's job to order a new trial on liability, if that's the situation, correct?
That is the court's decision. Did the trial court abuse its broad discretion?
Well, let me follow up on this question. I thought I understood your theory to be on the 0%, which is that the jury could go back and deliberate and say, gosh, it really looks to us like this wouldn't have happened if Starbucks had done their job and had adequate warnings and so on and so forth. So we're not going to necessarily excuse what the ward did, but we understand in the context of comparative negligence, we think it's 100% on Starbucks in this instance.
Yes, sir.
And I think, I'm not making your argument for you, I think that's,
Yes,
I
sir.
think that, isn't that your argument, then your briefs are?
It is. The jury decided that this is 100% the fault of Starbucks, not the driver, because this is something that Starbucks should have
Well,
foreseen and
I'm sorry to
prevented.
interrupt again, because I know we have limited time.
Yes, sir, Your Honor.
But
Thank you.
do you have a case out there, is there a case somewhere in Florida, maybe elsewhere, that says, okay, there was admitted negligence by one of the defendants, yet the court upheld a comparative negligence that had 0% assigned to that person?
I'm not aware of that, Your Honor, but I do know that the jury does not have to accept even unrebutted expert testimony that it was someone's fault. The jury does not have to accept someone's opinion that it was their fault because she liked their coffee. And that's what happened in this case. There is one case that I would like to discuss, which is akin. There's not a case on point, Your Honor, that I'm aware of. There is a case akin, which is the Levy versus Home Depot case. This is a 3rd DCA 1987, in which they quote Prosser and Keaton on torts when they talk about when there's a condition in which someone may have their arms full of bundles, it may be anticipated that the visitor will not be looking for a hazard. That's akin to this case. Starbucks placed that coffee and placed that biscuit in her hand, knowing that she would be distracted pulling out of the drive-thru. At the same time, Starbucks made the decision to put Xing pedestrians into that blind corner where this happened. So a jury could hold that a woman with arms full of bundles walking on a sidewalk is not responsible for tripping over a 3-inch hazard on the sidewalk. It is foreseeable that this person would be putting her receipt in her purse and eating her biscuit or taking a sip of her coffee for 1 second. And the jury can decide it's not her fault. She's not negligent for causing this. It was Starbucks who set the trap for these two people, two victims in this case, to fall into. My argument, ladies and gentlemen of the jury, you can assign 0%, you can assign 5%, but that's your job. It's not the government's job, it's not the judge's job, it's the jury's job under our Constitution.
What about the empty chair argument not being permitted?
I'm sorry, say again, Your Honor?
What about the empty chair argument not being permitted?
Well, it was permitted. It was never prohibited. In fact, you can see it in their argument.
Well, I did see in their argument, and I would agree with their characterization, that they came about as close to it as you could without getting whacked with a gavel. So they got a lot of benefit from it, but when you settled with the landlord on Sunday afternoon before Monday starting up, and then you claimed you were prejudiced, I think they might have had the same claim that they were surprised or at least prejudiced. But why couldn't they argue empty chair? I mean, I don't think it would have been successful because it's an all or nothing deal, and I think probably after the evidence, I'm not sure it would be successful, but why weren't they at least allowed to give it the old college try?
Number one, Your Honor, they did, and they were allowed to. The court never prohibited them from doing so. The court said you have a duty, that is a matter of law. That was the only ruling.
Court said it was too late and too cute.
Too late, too cute to argue they didn't have a duty.
Too late and too cute to argue empty chair.
Your Honor, I believe that was not on the empty chair issue. It was, in fact, on them trying to argue they didn't have a duty in this case. In fact, we know that the court didn't rule on the empty chair because he didn't shut them down when they made that argument in closing, and we did not object. They never put these people as Fabre defendants.
Page 617, the court, this is all too cute. How could it be? We're here, plaintiff had known there would be this quote-unquote empty chair defense. There have been alterations to the presentation of evidence. So it most certainly was about the empty chair, and they were not permitted to make a full-blown empty chair. Again, I agree. I don't think it would have been successful since it's all or nothing, but how can they be prevented from that? The case law is clear. A general denial, which they made among other things, a general denial is all you need to make the empty chair argument, right?
Well, not necessarily. They have conflated the duty issue into an empty chair to try to create an empty chair appeal. What is the empty chair? I think we need to address that. The empty chair rule is that when a non-party is alleged to be the sole cause of the injury at issue, the sole cause. What was Starbucks Corporation's opening statement? There are two people who caused this, an inattentive driver and an inattentive pedestrian. We're not talking sole cause. That is their opening statement. Those were their five defenses. If you're going to allege sole cause, you have to have sole cause of the injury at issue. This is not the Vila versus Philip Morris case, in which they put into evidence that the man who was addicted to cigarettes got addicted in foreign countries made by cigarette makers that were not Philip Morris. And they put that evidence into the record, and then they were prohibited from arguing empty chair. This is not the USF case versus Carter, in which they wanted to put into evidence the testimony of the expert that said the sole cause of this injury was the failure to give antibiotics by the critical care team. They are prohibited from putting in that evidence to prove the sole cause. This is not a sole cause argument. They were blaming everybody else, and then at the last minute, they wanted to utter the magic words of empty chair, which is not what the law allows. The law allows, if you're going to argue a sole cause, that's empty chair. They didn't do that here. They wanted their cake, they wanted to eat it too, and they wanted a free bite at the apple. And that's not what the law is. If that's the law, all they have to do is utter empty chair at the end of every case, and we'll never have finality. In this case, they were not prevented from putting one iota of evidence in, not once. In the USF versus Carter case, they were prevented from putting in that expert testimony that the failure to administer antibiotics was the sole cause. In the Philip Morris case, they were not allowed to argue empty chair because the court didn't think, I don't like that argument. This isn't that case. No evidence was prevented from coming in. There's not an iota evidence that someone else was a sole cause. In fact, this drive-through was the exclusive possession of Starbucks Corporation. It's under the lease. They had control over it, and absolute control. This is not some outside party. So, Your Honor, I don't think the empty chair is a valid argument, and I don't think that they thought they were prohibited from arguing it, because they did in closing argument. We didn't object, and the court didn't shut them down. So in closing, I'm not going to take up all my time. The trial court properly precluded Starbucks Corporation from confusing the jury on its duties under Florida law. That is a question of law for the court, not for the jury, under the guise of inapplicable, last-minute, empty chair argument. Indeed, to conclude otherwise would create an untenable rule. The empty chair defense would become magic words that, no matter when uttered, up to and including the last day of trial, would entitle the defendant to a do-over if they're unhappy with the verdict. That is not and cannot be the law. Thank you.
All right, thank you.
I'd like to spend my remaining time addressing the empty chair as well, but before I do, I want to go back to one point as it relates to the duty owed by the landlord versus the tenant, and one distinction that I think is significant, which is that in the cases cited by Gold, which include the Levy case versus Home Depot and the Burton case, and specifically Levy, because Levy says that the holding or the analysis in Federated was not applicable. And when it said it was not applicable, it said it was not applicable because Home Depot, the Levy case, involved a static condition. And that static condition was an uneven or a 10-inch gap in the sidewalk. And similarly, Burton involved a elevated divider in the parking lot. Static conditions. There was nothing static about the conditions at Starbucks that were involved in this accident, and that is why the holding of Federated and Jeffrey apply in this case instead of Levy and Burton. This case is anything but static. It involved motion by multiple parties, Ms. Gold as the pedestrian, Ms. Ward as the driver, moving around in her vehicle and obviously a moving vehicle. And so, again, based on all that movement and the lack of a static condition, that is why those cases are not applicable.
Quick question, if there hadn't been a settlement on the Sunday before trial, what would the verdict form have looked like? Wouldn't it have been apportioning negligence among the defendants?
Absolutely, Your Honor. It would have been any comparative on Gold and then Island Walk Station as the landlord.
So this can't be unusual where someone settles and there's multiple defendants. I mean, typically I would think that there's an ability of the plaintiff to argue at least some of the negligence of the settling defendant contributed.
Yeah, agreed. And I don't think it is. I mean, I think even the Levy case, if you look at that, there was a settlement of the landlord prior to that, and it left the tenant hanging out there. And so again, to move toward the empty chair defense and the argument, yeah, I think that was exactly the question, Your Honor. I mean, here we are Sunday afternoon before trial. The landlord is now out of things, and so the question is, do we name them as a fabre based on an alleged shared duty, or do we attempt to empty chair them based on the fact that under the lease, they are responsible for the common areas, which include the parking lot where this accident happened? And so to the point of what was required and what occurred, I think the context and the timeline of that is important too, because the first notion to the plaintiff that we intended to pursue an empty chair was not after the close of their case. We talked about it early on in the trial, and the trial court was the one who said, I can shut that down via motion in limine. But despite saying that, the case proceeded all the way through plaintiff's case, and there was no motion in limine filed until that Sunday after they had closed their case and Starbucks was to start their case. And that motion in limine, again, erroneously stated Florida law as to the landlord's duty in a situation like this, given that there was no static condition. But beyond that, again, we had satisfied all the prerequisites for that empty chair. And so when the court initially granted the motion and said, do you have anything that says she, referring to me, can't do what she's doing? The response was no, just that it had not been pled as an affirmative defense. We readily responded to that, saying an affirmative defense is not required. It's just a general denial. And the court on its own came up with a prejudice argument. It was never argued by plaintiff that they were prejudiced, and to the contrary, they had been or should have been expecting us to assign fault in some context to the landlord. So it wasn't just, a suggestion of magic words or that, that was an easy out for us after the fact. There was always an intention that Starbucks would split whatever liability came its way with the landlord because of that arrangement.
There were no cross claims, were there?
There was not, Your Honor. Obviously, the lease provided for the potential for indemnification, but there were no cross claims. But there was always the potential that they would share whatever liability, however that looked, whether it was all parties listed on the verdict form or through the assertion of an empty chair defense. And in this case, Starbucks was wrongfully precluded from pursuing that defense. And again, as close as the line as we could, but certainly not the full extent of what we would have argued and alleged had we been able to present that empty chair defense. Thank you, Your Honors.
Thank you.